the secret Criminology made easy. And today I will continue my discussion in non-institutional correction, is specifically in Presidential Decree 968 concerning the process to be observed in applying for probation until its termination. According to the law, after promulgation of judgment, the offender will be given 15 days to choose either to file an appeal or to apply for probation in case that the offender is qualified for probation program. So in case he is qualified, now, ang sabi sa batas ay magpa-file ng application itong offender na ito at ang gagawin ng korte ay temporarily he will suspend the execution of the sentence imposed in the judgment. And pending the submission of the post-sentence investigation report and the resolution on the application, the applicant may be allowed on temporary liberty and under his bail filed in the criminal case. Now, paano kung walang pang-bail, walang pambayad ng bail yung offender? Ang sabi sa batas, in case where no bail was filed or the applicant is incapable of filing one, the trial court may allow the release of the applicant on recognizance to the custody of a responsible member of the community who shall guarantee his appearance whenever required by the trial court. That is under Section 13 of the probation rules, the implementing rules and regulation of probation under Executive Order 292, also known as the Administrative Code of the Philippines in 1997. Now, so isususpend niya, yung judge will suspend the execution of judgment, and then after that, the trial court may notify the concerned prosecuting officer of the filing of the application at a reasonable time it deems necessary before the scheduled hearing thereof. That is based on Section 9 of the probation rules. And then the prosecuting officer may submit his comments, if any, on the application within a reasonable time given to him by the trial court from his receipt of the notice to comment. That is under Section 10 of the probation rules. Now, pagkatapos mag-comment ng prosecuting officer at ito ay maibigay niya sa judge under Section 11 of the Rules of Court, ang sinasabi niya dito, if the trial court finds that the application is in due form and the applicant appears to be qualified for the grant of probation, it shall order the city or provincial parole and probation office within its jurisdiction to conduct a post-sentence investigation. Ano ang purpose ng post-sentence investigation? It is to determine that the ends of justice and the best interest of the public as well as the dependent will be served in granting or denying probation, both for the society and for the offender, applicant, petitioner. Titignan kung makabubuti ba pareho doon sa offender, sa applicant, at dito sa society, sa community na siya ay itong offender na ito ay bigyan ng probation. So in case na makita ngayon ng probation officer na okay ang offender safe ang community, ang society. So, pwedeng maging basis iyon ng korte in deciding whether the application will be granted or it will be denied. Okay, so yan yung trabaho ng post-sentence investigation. At ang post-sentence investigation, ang magkakandak dyan ay walang iba kundi ang PPA through the probation officer. Okay? And then within 5 working days from the receipt of said delegated assignment, the probation officer shall initially interview the applicant if he appeared in the probation office upon response to the 72 hours limitation given to him by the trial court. Now, if not, the probation officer on case may write the applicant in his court given address or personally visit applicant's place to schedule an initial interview at the probation office. Okay, so kung hindi nagpakita yung aplikante, yung petitioner, then mismong yung probation officer ang pupunta sa kanilang lugar para lamang siya ay ma-interview. During such initial interview, the probation officer on case or the CPPO shall require the applicant to accomplish and sign a post-sentence worksheet or the PPA Form 1. And then the investigating probation officer on case shall conduct further investigation based on the information contained therein, and the petitioner is required to execute and sign a waiver cum authorization form, and that is PPA Form 2. So ang waiver cum authorization it is a waiver authorizing or allowing the PPA or the probation office to secure any and all information on the applicant under Section 15 of the probation rules. So, okay na lahat. By the way, in case that the petitioner did not present himself within 72 hours or hindi siya mahagilap ng probation officer at ginawa ng probation officer yung kanyang best para siya ay mahanap at ma-interview and yet wala pa ring result, this petitioner will be considered as an absconding applicant. Okay, absconding applicant. At kapag ikaw ay absconding applicant, ay pwedeng maging basis yon for the denial of your application, because that is one of the major condition in applying for probation. Okay? Pero kung okay naman, nagpakita siya, so ang next na process ngayon is yung submission ng post-sentence investigation report. Yung pagkakandak ng post-sentence investigation it will last up to 60 days. Okay? Up to 60 days. So ang sabi dito, under Section 11 of the probation rules, the probation officer shall submit to the court his post-sentence investigation report for not later than 60 days from the receipt of the order of the said court to conduct investigation. So lahat ng information na nakuha at nakalap ng probation officer at yung kanyang investigation, gagawan niya yan ng summary magre-report siya sa court at isasubmit niya yung lahat ng kanyang nakuhang information. Now, the investigation report to be submitted by the probation officer shall be in the form prescribed by the probation administrator and approved by the Secretary of Justice. That is under Section 6 of the Presidential Decree 968. And that form is the Post-Sentence Investigation Report Form or the PPA Form 3. Okay? Yan yung ibibigay ng probation officer sa korte sa judge. Now, pagkatapos na ma-receive ng judge yung report ng probation officer, yung PSIR, Post-Sentence Investigation Report, the court shall resolve the petition for probation not later than 15 days after the receipt of the said report. Now, pending submission of the investigation report and the resolution of the petition, the defendant may be allowed on temporary liberty under his bail filed in the criminal case. In case na hindi pa siya nakapag-file ng kanyang bail or in case na hindi pa siya nire-release ng korte. However, in case where no bail was filed, so yung kanina ito, the court may allow the release of the defendant on recognizance under the custody of a responsible member of the community. Now the question is the court bound by the findings of the probation officer? Ibig bang sabihin, ito na ba ang magiging basis ng judge para siya ay mag-decide? Meaning, yung sinubmit ng probation officer na PSIR ay required ba ang judge na sundin ito? So kung sinabi ba ng probation officer doon sa kanyang report that the applicant was qualified to avail the program, and then ang judge ay susunod na doon at sasabihin niya maglalabas siya ng resolution granting the request or the report of the probation officer. Tingnan natin kung ano ang sinasabi dito. The answer is no. The court is not bound by the findings of the probation officer, but they will be taken into consideration. Magiging basis siya. In other words, said findings are only considered as recommendation to the court. And the court has still the final say whether probation shall be granted or denied. It is still the discretion of the judge whether to grant or deny the application of the petitioner. Okay? So only basis or it is only a recommendation para lamang merong basihan yung pagde-decide ng judge. Bakit meron pa yan? Bakit binigay pa ang post-sentence investigation? It is required by the law. And para merong basis ang korte sa kanyang magiging decision. Okay? Next. In either granting or denying probation, what shall the court consider? Number 1, in determining whether an offender may be placed on probation, the court shall consider all information relative to the character, antecedents, environment, mental and physical condition of the offender, and available institutional and community resources. Okay? So lahat yan ay titignan ng korte, hindi lamang ang post-sentence investigation report. Of course, yung iba dito ay nakapaloob sa isasubmit ng probation officer na report from the post-sentence investigation. Another, if the probation shall be denied, if the court finds that the offender is in need of correctional treatment that can be provided most effectively by his commitment to an institution. So makikita lahat yan. Makikita doon, malalaman ng judge kung mas magiging effective, mas magiging safe, kung siya ay mag-i-stay na lamang sa loob ng kulungan. Okay? Kung mas mapapabilis ang kanyang treatment. There is undue risk that during the period of probation, the offender will commit another crime. So yan yung iniiwasan, yung safety and security still ng community. Probation will depreciate the seriousness of the offense committed. Okay, next. Number 6 is the effectivity of probation order. A probation order shall take effect upon its issuance, at which the court shall inform the offender of the consequences thereof and explain that upon his failure to comply with any of the conditions, mandatory and yung tinatawag na conditional, hindi siya mandatory, with any of the conditions prescribed in the said order or his commission of any offense. Meaning, pagkalabas ng probation order ay doon na nagsisimula yung visa ng kanyang probation order. Okay? So, hindi ka pa maghihintay ng 15 days, hindi ka na maghihintay ng 10 days, or even 5 days. Upon the release of the probation officer of the probation order, ay nag-took effect na or effective na yung probation order. Appearance to probation officer. Now, if probation is granted by the trial court, the probation officer or the trial court may direct the applicant to report to the proper probation office within 72 hours from its receipt of such order. Kanina, balikan natin, upon filing of the application at nakita ng korte na pwede at pasok siya sa mga qualification, then bibigyan siyang time na mag-report sa probation officer, at pag hindi siya nag-report for 72 hours, ay makukonsider siya as an absconding applicant. Okay, absconding applicant. Now, dito, granted na yung kanyang probation application at siya ay considered na as probationer, then ang sabi ng batas ay kailangang mag-report ng probationer sa probation officer within 72 hours period. Okay? And this requirement is a mandatory condition sa kanyang probation. Meaning, once you violate this condition, ay pwedeng ma-revoke yung kanyang program, yung kanyang probation, at ibabalik siya sa kulungan to serve his original sentence. So it is a mandatory condition of probation for the probationer to present himself to the probation officer designated to undertake his probation at such place as may be specified in the probation order within the said 72 hours from receipt of said order. That is under Section 10 of Presidential Decree 968 and Section 12 of the Implementing Rules and Regulation of Probation. Now, kung sakaling siya ay hindi nag-appear, okay? Halimbawa, hindi siya nagpakita within 72 hours, he will be considered as absconding probationer. Okay? Absconding probationer. Kanina, absconding applicant. Dahil hindi pa nag-grant yung kanyang application. Now that it was already granted, ang category niya na ngayon ay absconding probationer. Question: when a probationer appears for initial supervision, what shall happen next? Ano ang mangyayari? Upon the probationer's appearance for his initial supervision, the supervising probation officer on case or CPPO himself shall give instructions to the client using PPA Form 4 in order to reinforce probationers' awareness of the probation conditions specified in the probation order in a language or dialect understood by him. Another, formulate with the client the supervision treatment plans and carry out other related activities. So, paplanuhin ngayon. Yun yung purpose why the probationer is required to present himself to the probation officer within 72-hour period para plantsahin at planuhin yung magiging programa, magiging kondisyon doon sa probationer habang siya ay nagsiserve ng kanyang probation sa community. Okay? Next. What if the probationer failed to present himself to the probation officer with a 72-hour period? Of course, siya ay tatawaging absconding probationer, na-discuss natin yan kanina, at isa ito sa magiging basis for the revocation ng kanyang probation. Remember, ito ay mandatory condition sa lahat ng mga probationer. Okay? Once na ikaw ay nag-fail, hindi ka sumunod dito, it is a clear violation of the condition for probation. Next. What is the effect of being absconding applicant or probationer? Nandiyan na yun, it will be a basis for the revocation. Now, concerning control and supervision of probation, what are the primary purposes of probation supervision? Number one, ito ang trabaho nila. Number one, ng mga probation officers, to ensure the probationer's compliance with the probation conditions is specified in the probation order. Okay? And the prescribed probation treatment and supervision program. Okay? So, para lamang ma-assure na nasusunod yung mga conditions, nasusunod yung mga treatment program na ibinigay sa probationer. Number two, to manage the process of the probationer's rehabilitation and reintegration into the community. Okay? Thirdly, to provide guidance for the probationer's transformation and development into a useful citizen for his eventual reintegration to the mainstream of society. Section 38 of the probation rules. What are the two main functions of probation? Number one, to conduct post-sentence investigation. And number two, to supervise the convict if he is granted probation. Number three, kung ating idadagdag, of course, to submit post-sentence investigation report to the judge or to the court. Okay? So yan yung pinaka-main function ng probation officer. To conduct post-sentence investigation, to submit post-sentence investigation report to the judge or to the court, and to supervise the convict if he is granted probation. Okay, number 9, termination. Patapos na tayo, termination. After the period of probation and upon consideration of the report and recommendation of the probation officer, the court may order the final discharge of the probationer upon finding that he has fulfilled the terms, the condition, the treatment process of probation, if there is a changes, kung positive ba yung pagtanggap niya, na-rehabilitate ba siya, corrected na ba yung kanyang attitude, na bago yung kanyang perspective. So pag nakita yan ng korte, okay, at natapos na yung prescribed period of probation, then the court may order the final discharge of the probationer. Okay? Now, the final discharge, take note, of the probationer shall operate to restore to him all civil rights or yung suspended na rights niya dahil sa kanyang conviction ay totally marirestore yun sa kanya. Okay? As if na ikaw ay wala ng kasalanan. So the probationer and the probation officer shall each be furnished with a copy of such order. Okay? So ibig sabihin, bumalik na lahat sa iyo yung karapatan mong bumoto, yung karapatan mong tumakbo sa office, pagiging Pilipino mo, or kung lahat ng karapatan mo bilang isang citizen ng bansang ito ay marirestore, ibabalik lahat yan sa iyo ng gobyerno. Okay? Next. Who are persons qualified to early termination of their probation? Mamaya makikita natin kung gaano ba katagal ang pagre-render ng service under probation program. Now, merong tinatawag na early termination. Ito yung mga qualification. Those who are suffering from serious physical or mental disability, such as deaf, mute, the lepers, the crippled, the blind, the senile, the bedridden, and the like. Okay. Pag ganyan na ang sitwasyon, so the court may decide for early termination. Another, those who do not need further supervision as evidenced by the following: consistent and religious compliance with all the conditions imposed in the order granting probation. Okay? Positive response to the programs of supervision, significant improvements in their social and economic life, absence of any derogatory record while under probation. Okay? Number 5, marked improvement in their outlook in life by becoming socially aware and responsible members of the family and community, and significant growth in self-esteem, self-discipline, and self-fulfillment. So yan yung ilan sa mga tinitignan ng korte sa probationer kung siya ba ay qualified for early termination. Okay. Other matters that must be considered in relation to probation. Okay. By the way, kung gaano ba katagal ang pagre-render ng probation. Ang sabi sa batas, Kung ang original sentence mo ay 1 year and below at ikaw ay nag-file ng application for probation, your probation program to be rendered in community will be 2 years. Okay? So, madodoble siya. 1 year and below, automatic yan, 2 years ang i-render mong service or sentence under probation program. Pwede na. Compare naman sa ikaw ay nasa loob ng kulungan na hindi mo kasama ang iyong family at ikaw ay wala sa community. Okay? 1 year and 1 day to 6 years, you will render 6 years under probation program in the community. Okay? So from 1 year and 1 day to 6 years, ang original sentence mo nandoon sa ranging from 1 year and 1 day to 6 years, ang ibibigay na years to be spent under probation program is 6 years, maximum of 6 years also. Okay? Now, other matters tayo before we end that must be considered in relation to probation. Probation is a matter of privilege. It is not a right. Okay? Hindi mo pwedeng i-demand ang gobyerno at sasabihin, it is my right, okay, na mag-undergo ng probation. No. It is only a privilege given to you by the government. Okay? It is a matter of privilege because only selected persons may avail of it. If probation is denied by the court after considering all information, then said resolution cannot be appealed because it is only an interlocutory order. By the way, in the application for probation, yung decision na nire-release ng judge ay hindi judgment, kundi resolution. Okay? Ang tawag doon ay resolution. Yung decision ng korte, whether granted or not, it is called resolution. Okay? It is not judgment. Now, what is the period of probation? Ito na pala, na-discuss na ito. The period of probation of a defendant sentenced to a term of imprisonment of not more than 1 year shall not exceed 2 years, and in all other cases, from 1 year, 1 day to 6 years, said period shall not exceed 6 years. So maximum is 6 years. Okay? These are the mandatory conditions of probation. Present himself to the probation officer designated within 72 hours period. Okay? Report to the probation officer at least once a month at such time and place as specified by said officer. Dalawa lang yung mandatory condition. Mag-report upon the release of the probation officer upon issuance, so the probationer will be given 72 hours, 3 days to report to the probation officer. Now, and pangalawa, at least once a month magre-report. Discretionary conditions, meaning it is upon the discretion of the probation officer kung i-implement yung mga iba pang condition. Number 1, cooperate with the program of supervision, meet his family responsibilities, devote himself to a specific employment, and not to change said employment without the prior written approval of the probation officer. Parang napakahirap, no? Especially dito sa Pilipinas, once na ikaw ay naging convicted criminals, parang ang hirap mong makabawi. But ito ay requirement. Pwede kang magtrabaho provided nakadeclare yan sa probation officer mo at merong approval coming from PPA through probation officer. Discretionary, undergo medical, psychological, psychiatric examination and treatment, and remain in a specified institution which is required for that purpose. Pursue a prescribed secular study or vocational training. That is only a discretionary conditions. Attend or reside in a facility established for instruction, recreation, or residence of person on probation. Refrain from visiting houses of ill repute, sa mga beer houses, mga nightclubs, mga ganon, or may mga sugalan, lahat ng klase. Abstain from drinking intoxicating beverages to excess. Permit to probation officer or unauthorized social workers to visit his home and place or work. Reside at premises approved by it and not change his residence without its prior written approval. And satisfy any other condition related to the rehabilitation of the dependent. So doon tayo magtatapos. Yan yung mga process to be observed in applying for probation and upon its termination. Next video is the summary of the process and different terminologies concerning probation system. So, hintayin lang natin, maybe this week or next week ay mag-upload ulit ako ng video sa pagpapatuloy ng ating discussion dito sa non-institutional correction. So, dito lang tayo magtatapos. Pag-aralan yung mga mabuti ito sa aking mga student and magkakaroon tayo ng graded recitation and even quiz concerning this video and the two videos that were uploaded doon sa mga naunang mga uploaded videos natin. So, thank you and God bless. And